everybody, I hope you're doing well. In this video today, we are going to discuss all the questions relating to Unit 3, other essential elements of a contract, which is under the Indian Contract Act 1872. So, before you watch this video, I hope you have finished studying Unit 3. Let me just tell you what are the concepts that you need to know before you dive into these questions. Firstly, the first element that we learned in this unit, capacity to contract. Usme the laws relating to minor, I want you to know all of these laws in depth. Then we spoke about the concept of free consent. Jisme we learned coercion, undue influence, fraud, misrepresentation, mistake and the consequences of the same. So those topics. Then we went on to another concept where the agreements are considered void because of the unlawful consideration as well as unlawful objective. Yes, I'm talking about section 23. And one of the points in section 23 was focusing on the agreements opposed to public policy. Jisme again at length we learned a few examples where the agreements are opposed to public policy. So that concept, then the agreements which are expressly declared void under the Act. And uske baad, usme se we learned a chotu sa concept called wagering agreements. So only and only if you know all of these topics in depth, you have understood them as well as learned them. Then only watch this video because this video will cover all the questions from May 2018. So let's start with the first question, which looks very simple and is actually simple unless somebody makes a very common mistake. So the first question says, examine with reason that the given statement is correct or incorrect. What is the statement? A minor is liable to pay for the necessaries supplied to him. Now at first glance, this may seem correct, but technically it is not correct. Why? You're absolutely right. It is not the minor who is liable to pay for the necessaries. If we recollect the laws, the specific point, which is also relating to section 68, says that it is a minor's property which is liable for the necessaries supplied to him and not the minor personally. So, at first glance, some of you may make a mistake and say that, okay, minor is liable for the necessary supply, this is correct. But the real point is, it is not the minor who is liable, it is the minor's property that is liable for the necessary supply. A minor can never be personally liable in case of a contract. It is only his property that is that is liable for the necessary supply to him. What if he does not have property? Then it is not going to be in any case where he is liable, because only if he has property. So the minor's property, if any, a minor ka estate, if any, is going to be liable for the necessary supply to him, not the minor. So the answer here is incorrect. The statement here is incorrect. So you will write the correct statement and you will also give your reasoning as to why this statement is incorrect. 2 marks के लिए है May 2018 का. Let's move on to the second question. Second question is again a direct question. Define fraud. Definition. Define fraud. Section 17. Then there is a concept. Whether mere silence will amount to fraud as per the Indian Contract Act. I have said this over and over again in class. The concept of fraud, not fraud, the concept of fraud as well as mere silence amounting to fraud is one of ICAI's favorite questions in terms of the direct question point of view. So what do you write for this? First, you write the definition of fraud. Definition of fraud, if you see my notes, which is right here. Right? We have a definition of fraud which is given under section 17 and I've told you that I would like you to write this definition as it is. All the points, 1, 2, 3, 4, 5, everything has to be covered in your definition and you have to study this as it is as per section 17. So it means and includes till the end. You have to write this much. Now, is silence equal to fraud? Yes or no? Does mere silence amount to fraud? Uske liye also we have a few things that we're supposed to study. Here I've only listed out the examples, but we have discussed this in class. If you just keep silence regarding certain facts of the case, which need not be disclosed, then it is not considered as fraud. You are not obligated to disclose every single thing unless the other party has asked you to do that. So just keeping silence about some facts of the case is not equal to fraud. Mere silence does not amount to fraud unless it is the duty of the person to speak or his silence amounts to speech. We have seen this in point 2 and 3 also. So since this is a direct question, it should not be difficult. It was given for 5 marks in May 2018. Then there's a similar question on those lines itself, which was asked in May 2019. Since it is similar, I've kept it under the same question. Mere silence is not fraud, but there are some circumstances where silence is fraud. So I told you the second part of this. Silence is considered as fraud in 2 cases. Case number 1, where it is the duty of the person to speak. Case number 2, where silence is equal to speech. Now they have also asked you explain the circumstances as per the provisions of the Act. So we know a few cases where it is the duty of the person to speak. It is the duty whenever they are sharing a fiduciary relationship, where if it is a contract of insurance, if it is a contract of marriage, if it is a contract of family settlement, and if it is share allotment contracts. So all of those points have to be listed here because those are the cases where it is the duty of the person to speak. Another case where silence is fraud is where silence is equivalent to speech. Iske liye also we had done several examples. If I see the notes, this part, duty to speak, silence is equal to speech. These 2 topics have to form a part of your answer. This is a direct question. This was asked for 7 marks in May 2019. So the entire concept of fraud is covered in this. Of course, there are a few more things about fraud, like what are the consequences of fraud, that is also asked eventually. So that shows us how important this topic of fraud is. So second question is done. Great guys. Let's move on to the third one. Third one again happens to be a direct question. It's just an observation from all the questions wherever I've done the analysis. This unit relating to fraud, undue influence, coercion, misrepresentation, majority of the questions are direct. It's only relating to laws of a minor, or if we are talking about agreements opposed to public policy, or cases where there is unlawful consideration and objective. They have asked a few case study questions, but otherwise most of it is direct. But you never know, in the future attempts, it could also become a case study question. But we are prepared for either of them. So looking at question 3, discuss the essentials of undue influence as per the Act. So you will start with not the essentials of undue influence, you will start with the meaning of undue influence, which you have learned under section 16. Once you are done discussing that, once you are done explaining the meaning of undue influence, you may add an example, and uske baad in depth you will talk about the essentials of undue influence, given that it is carrying a weightage of 5 marks. Now what are the essentials of undue influence? Firstly, we have to check the relation between the parties. Should there be a relation or should it not be there? It has to be there. A relation needs to exist. Now, if a relation needs to exist, what kind of relation? A relation where one person is in a position to dominate the will of the other person. That is also important. Now, once the contract has been entered into, what happens? What is the purpose of entering into this contract? So, your objective or purpose, which is to take undue advantage, is important. And after purpose, say the contract has been entered into, what happens if either of the parties want to file a case? Who can file a case? The aggrieved party can file a case. So your next point, which should be covered in the essentials, is the burden of proof. Burden of proof. So these points have to be explained in depth in your essentials of undue influence. Again, a direct question, simple one. Even the next one is direct on the same lines. I think the whole chapter is there here only relating to free consent. Next, explain the term coercion and what are the effects of coercion under the Act. We have learned coercion under section 15. Let me take you to the definition. The first part, coercion is where you are threatening to commit or you're actually committing an act which is forbidden by the Indian Penal Code, or there's another case which amounts to coercion, threatening to detain or unlawful detaining of any property to the prejudice of another person. So once you write the meaning of coercion, you have to give the effects of coercion. What are the effects of coercion? A contract which is entered into using coercion is obviously voidable. Voidable at whose option? Voidable at the option of the aggrieved party. Now, if the aggrieved party has rescinded the contract but still received some benefit out of it, that benefit has to be restored. So that also is a consequence or an effect of coercion. Then you had learned one more thing under Unit 6. If you have finished Unit 6, you can add this now itself. Otherwise, when you finish Unit 6, it will automatically form a part of your answer. Section 72. If you've received anything under coercion or by mistake, it is your duty to return it. So that is also the effect of coercion. Please add that point when you write effects of coercion. Okay, simple question, direct question to the point, no need of breaking our head in the exam. Of course, we have to break our heads before the exam to understand and to remember all of these points. Moving on to question number 5, which is another case study question for us. Mr. X, a businessman, has been fighting a long-drawn litigation with Mr. Y, an industrialist. To support his legal campaign, he enlists the services of Mr. C, a judicial officer, stating that the amount of rupees 10 lakhs would be paid to him if he does not take up the brief of Mr. Y. Let's understand what has happened here. Mr. X has been fighting a long-drawn litigation with Mr. Y. So, Mr. X और Mr. Y का झगड़ा चल रहा है. Now, what has Mr. X done? In order to support his legal campaign, he enlists the services of Mr. C, an officer, and he specifically tells Mr. C that I will pay you 10 lakh rupees. To who? To Mr. C. And what is the consideration that he's asking for? He's saying that in exchange for the 10 lakh rupees, I would want you to not take up the brief of Mr. Y. So the consideration which Mr. C should give is not taking up the brief of Mr. Y. Right? This is the exchange that Mr. X has asked for. Now, Mr. C has agreed to this. He shouldn't have agreed, but he has agreed to this. And at the end of the litigation, Mr. X refuses to pay Mr. C. So, Mr. C refused the brief of Mr. Y, and uske baad, when he went for his amount, Mr. X is refusing to pay. So, let's see whether, the question is, whether Mr. C can recover the amount promised by Mr. X under the provisions of the Act. What would I cater to here? Firstly, by the first glance itself, we know that this agreement is not lawful. Why is this agreement not lawful? Because the consideration in this agreement is unlawful. We had learned section 10, the essential elements of a valid contract in unit 1. Jisme we learned one of the essential elements, point 5 in our material, that the consideration should be lawful as well as the objective should be lawful. Then we learned section 23, which gives us cases where the objective as well as the consideration is unlawful. And this happens to be in that case. Further, you have studied one more section, agreement in restraint of legal proceedings, section 28. Here, the agreement that was entered into between X and C is where X stopped C from taking up the case of Y, which is again unfair. So, the result is, can C recover the amount promised by Mr. X under the provisions of the Act? Absolutely not. These are your 3 provisions which will be applicable, and then your conclusion will be applying these above provisions. Mr. C cannot recover the amount promised by Mr. X since the agreement between them included unlawful consideration as well as unlawful objective, and it was in restraint of legal proceedings. This should sum up your answer. This was asked in November 2020 for 4 marks. So, provisions, facts of the case as well as conclusion. Simple question. You just have to be conceptually very thorough to know what exact question is being asked here or what exact provision they are referring to. You know, many times I have experienced this as well as heard this from students. When I used to study law as well, I would encounter this. That after looking at the answer, the question would seem very simple. The issue is that you have to arrive at the damn right provision which is applicable in this case. Now that can happen only if you're conceptually thorough as well as thorough with the content then. But content is secondary. First you have to understand which concept they are talking about here. And once I tell you that these are the 3 provisions applicable, that will make sense to you because you're already familiar with it. It's just arriving at what provision is applicable in this case. That is where case study questions in the case of business law become challenging. So we need to work on that. Which is why classes and examples become more important. Anyway, addressing your 6th question, again a direct question. Define misrepresentation. So misrepresentation is defined under section 18. And fraud, which we just saw, section 17. Okay? So once you give the definition of both of these cases, next question is explain the difference between fraud and misrepresentation as per the Indian Contract Act. I won't explain all of this right now because it is a direct question. Your study material in Unit 3 itself, after fraud and misrepresentation, there is a table which gives you the differences between fraud and misrepresentation. That will form a part of this answer. So we're done with 6 questions. Let's move on to the 7th one. This was also, by the way, November 2020, 7 marks. Cool, not bad. 7th one, case study questions. My favorite type. Mr. S, one of the parties, aged 58 years, was employed in a government department. Now, if age is mentioned here, it will have relevance somewhere later on. He was going to retire after 2 years. Obviously, the compulsory retirement is at the age of 60 for a government employee, okay? Mr. D made a proposal to Mr. S to apply for voluntary retirement from his post at the age of 58 itself. What is Mr. D doing? Mr. D is making a proposal to Mr. S, saying, Mr. S, please retire. Voluntarily, I would want you to retire. Why is he asking Mr. S to retire? He's asking Mr. S to retire so that Mr. D can be appointed in his place. So Mr. D is telling S, boss, you leave voluntarily. I don't want to wait for another 2 years. After you leave, I will automatically be appointed in your place. Okay. Mr. D also offers a sum of rupees 10 lakhs as consideration to Mr. S in order to induce him to retire. Someone's actually paying a person to retire. It sounds like a dream offer, but not very valid in the court of law. We know why. Mr. S refused at the first instance, which I believe is the right thing to do. But when he evaluated that the amount offered as consideration is just double of his cumulative remuneration to be received during the tenure of 2 years of employment. So he did the math. Our Mr. S is also very smart. He calculated and he's like, if I retire now, I will get more money than I actually work. So after that calculation, he agreed to receive the consideration and accepted the above agreement to receive the money to retire from his office. Whether the above agreement is valid, explain with reference to the provisions of the Indian Contract Act. If I tell you in plain sight, without using any legal terms, Mr. D is bribing Mr. S to leave so that Mr. D can be appointed in that office. He wants that position and he is bribing S with a sum of rupees 10 lakh rupees to leave. Where do you think this is falling from? Is the purpose of this agreement valid or unlawful? Of course it is unlawful. So we learned in section 10 that the consideration as well as objective should be lawful. Then we learned something called section 23, where we learned all the agreements which have unlawful consideration and unlawful objective. Try remembering the points from that. One of those points were trafficking relating to public offices. Offices matlab positions. What is Mr. D doing here? Mr. D is buying the position from Mr. S. Whereas in case of a public office or any other office for that matter, you're not supposed to buy a position, you're supposed to earn it, right? Mr. D here is buying it. So here it is trafficking of public offices, which is where the consideration as well as the objective becomes unlawful. So is the agreement valid? Absolutely not. The agreement is void in this case. Whenever it comes to the question of a public office, money consideration is not something that should be involved. If you are going to be appointed in a public office, since the public is interested in that, it should be based on caliber and not based on how much money you are exchanging with another person under the table. So I hope this provision is clear. We will start with section 10, section 23. Write the provision relating to trafficking of public offices, then give the facts of the case, and then your conclusion. This question was January 2021 ka for 4 marks. Simple question. Simple, I know. It will become simple if you practice more. Okay. Eighth one I swear is simple. Examine the validity of the following contracts as per the Indian Contract Act 1872, giving reasons. Now, I have to tell you this before we start. This part 2 now, it is actually relating to unit 4. I will cover it right now, but technically the explanation of this answer is given under unit 4. We'll still cover it because something you should know, okay? First one, X, aged 16 years. Here itself, we know what the topic is going to talk about. Borrowed a loan of rupees 50,000 for his personal purposes. A few months later, he had become a major. 2 saal baad, 24 months की बात कर रहे हैं लोग. A few months later, he had become a major and could not pay back the amount borrowed on the due date. The lender wants to file a suit against X. Tell me whether it is allowed or not allowed. Obviously not allowed. You cannot file a suit against Mr. X. But Mr. X is a major, right? After he becomes a major, what is the problem in filing a case? Second point, under laws relating to a minor. What did we learn? We learned that a minor's contract cannot be ratified. What is the meaning of this? That once a minor has entered into a contract, it is void ab initio, which is void from the very beginning. Just because the minor has now become a major, will the contract automatically become valid? No. A law relating to a minor specifies to us that a minor's contract cannot be ratified. But there is also a point where a minor's property is liable for the necessary supply to him. Now, if this was for necessaries, at least the supplier, that is the lender, could have claimed from the minor's property. But since it is expressly given to us that it's for personal purposes, this will not come under the section 68 wala case. The answer is the lender cannot file a suit against Mr. X even though Mr. X is now a major, because the agreement was entered into while he was a minor, and according to the laws relating to a minor, a contract with a minor cannot be ratified. Okay. Second one, those who feel like, cover it, otherwise it's okay. J contracts to take in a cargo for K at a foreign port. So the contract is between J and K. J's government afterwards declares a war against the country in which the port is situated, and therefore the contract could not be fulfilled. You know unit 1 at least, right? We learnt in unit 1 that once a contract is valid, if there is an unforeseen event that arises, the contract becomes void. Now here, what is the unforeseen event? The war that J's government has declared is the unforeseen event. When J and K entered into a contract, it was absolutely valid. After that, once the war was declared, it became impossible to complete the contract. So the question is, K wants to file a suit against J. Is it allowed or not allowed? You tell me. Is it J's fault that he did not complete the contract? Absolutely not. There was an unforeseen event which took place, because of which the contract became void. So in your unit 4, you will learn this concept called as supervening impossibility. Section 56 is where you will learn this. Supervening impossibility or subsequent impossibility, where a contract at the time of formation is valid, but eventually, because of some unforeseen event, it becomes void. And one of the unforeseen events, which is mentioned under section 56, is declaration of war. So therefore, K cannot file a suit against J because of the contract becoming void. And why did the contract become void? Because as per section 56, there was a supervening impossibility, which in this case was the declaration of war. So this was question number 8. It's not yet done. We have a couple of more questions. Let's quickly move on to question number 9. Let's look at question number 9. Shrishti, a minor, falsely representing her age, enters into an agreement with an authorized laptop dealer, Mr. Gupta, owner of SP Laptops, for the purchase of laptop on credit amounting to rupees 60,000 on the 1st of August 2021. So Shrishti is a minor. She falsely represented her age to Mr. Gupta. Okay, let's put S and G. Shrishti is the minor here and Mr. Gupta is the owner of SP Laptops. And this agreement was entered into on the 1st of August 2021. She promised to pay back the outstanding amount with interest at 16% per annum by the 31st of July 2022 in a year's time. Okay, this is one promise. This is promise number 1. Next, what did she do? She told him that in case she will not be able to pay back the outstanding amount, her father, Mr. Ram, will pay back on her behalf. So this was the second promise that was made. After 1 year, when Shrishti was asked to pay the outstanding amount with interest, she refused to pay the amount and told the owner that she is a minor and he cannot recover a single penny from her. Bad girl, Shrishti. Okay, this is what she told him. I'm a minor, you can't recover a single penny from me. She's right though. She will become an adult on the 1st of January 2024. Only after which the agreement can be ratified. This is the third aspect that we're talking about here. Something seems wrong in this third aspect. We'll look at what it is. Now explain by which of the following ways Mr. Gupta will succeed in recovering the outstanding amount with reference to the provisions of the Act. I already feel sorry for Mr. Gupta, but let's see what the questions are asking us. Case 1. By filing a case against Shrishti, a minor, for the recovery of the outstanding amount with interest. So the first question is, can Mr. Gupta file a case on Shrishti, who is a minor? We already know the answer to that. Obviously not. The provision, according to Section 11 of the Indian Contract Act 1872, the persons who have the capacity to contract are majors, persons who are of sound mind, and persons who have not been disqualified by law. You can start with that and then specifically right here, Shrishti being a minor is not allowed to enter into a contract or is incompetent to enter into a contract. Therefore, the agreement that is formed between Shrishti and Mr. Gupta is void ab initio. Since it is void ab initio, a contract with the minor or by a minor is void ab initio, right? So can Mr. Gupta file a case against Shrishti? Answer is no. So in the case number 1, Mr. Gupta cannot recover the money. Let's see what happens in case 2. Case 2 is asking us, can Mr. Gupta recover the money by filing a case against Mr. Ram, the father of Shrishti, for recovering the outstanding amount? In the second point that I have marked here, Shrishti tells him that in case she is not able to repay the outstanding amount, her father, Mr. Ram, will pay it back on her behalf. Now, going back to laws relating to a minor, there were 2 related laws. One of the laws said, a parent or the guardian can enter into a contract on behalf of the minor, provided minor is at the receiving end of a benefit. And one more law said, a minor cannot bind the parent or the guardian. So can a minor Shrishti enter into a contract on behalf of her father with Mr. Gupta here? Absolutely not. Since Mr. Ram has himself not entered into a contract, Gupta cannot file a case on Mr. Ram. So here also the answer is no. Let's see the third case, because one more case is pending here. Third case is asking us, can Mr. Gupta file a case by, can he recover the money by filing a case against Shrishti, a minor, for the recovery of the outstanding amount after she attains majority? Just in the question before we had discussed this, that we know that a contract with a minor is void ab initio, it cannot be ratified. So even after Shrishti becomes a major, Can Mr. Gupta file a case on Shrishti? The answer is no. Because if you want to file a case against a minor, the contract does not allow you to do that. If you want to enter into a contract, you would have to enter into a contract with a person when they become a major, then you will be able to file a case, not otherwise. So there is no solution for Mr. Gupta in any of the three questions that is asked to us. How will you answer this? Provisions, the specific fact, conclusion. Very simple question, 6 marks ke liye. Many questions like this just freak the students out because of the length of the questions. It's usually the lengthiest of the questions that are the easiest. Okay, spend your time learning it, make a chart like this to understand what is happening, then tackle the questions. Do not judge the book by its cover. Do not judge the question by its length. Question number 10, easier. Since it's already covered, we'll just read it once. What are the effects of coercion? We have covered this. Section 15 for definition. Then the effects. One more question is there here which is new. Whether a threat to commit suicide is coercion. Now, the answer is yes. Threat to commit suicide does amount to coercion under section 15. What is the reason for the same? It is because suicide is an act which is forbidden by the Indian Penal Code. And as per the first point under coercion, threatening to commit or actually committing an act which is against the IPC is covered under the definition of coercion. So yes, threat to commit suicide does amount to coercion under section 15. Simple question, just for 2 marks in May 2025. Okay, let's continue. Question number 11. Direct question. What are the agreements which are held to be opposed to public policy under the Indian Contract Act 1872? Explain any 6 such agreements. So under section 23, we learned agreements which have unlawful consideration plus have unlawful objective, because of which, the result of which is that they are void. One of the points here was agreements opposed to public policy. That is the last point in our notes. Now, under the last point, we had a list of other cases which are opposed to public policy, right? This question is attacking you on that topic. I'll just show you at glance. Trading with enemy, stifling prosecution, champity, maintenance, we are talking about those cases, okay? See here. Agreements which are opposed to public policy, we have the entire list. So you will have to write the entire list. Maintenance and champity, trafficking relating to public offices, all of this has to be mentioned. Once we finish all of this, then you can choose which 6 it is that you want to go elaborate in length with and write that. Simple question, direct question. What are the marks? 6 marks. 6 marks, January 2025. That's a year ago. Alright. Question number 12. Explain with reference to the Indian Contract Act 1872 when a contract is said to be induced by undue influence. Again, a repetition of what we have just discussed in this video a while back, section 16, plus the essentials for undue influence. When a party is deemed to be in a position to dominate the will of the other. This is not something we had seen in detail. The second point, yes, we had spoken about it. See the first page, we had said relation, we had said position, purpose, burden of proof. But under position, there are a few cases where a party is deemed to be in a position to dominate the will of the other. Let me show you the notes. Yes. We have 4 cases. A person is deemed to be in a position to dominate the will in the following circumstances. First, where there is a real and apparent or an obvious authority, where cases where there is a fiduciary relationship which involves trust between the parties or mutual confidence between the parties. Point C talks about mental distress, where a person is temporarily in a distress and the other person is using his power or position to dominate the will of that distressed person. Finally, unconscionable bargains, where we had taken an example of moneylender, which basically means unfair bargains. You have that position where you are using that position to abuse the person who is in the other side. So that these 4 cases are where undue influence this answer will come. The cases where a person is deemed to be in a position to dominate the will. So since they have specifically asked that here, you would have to elaborate. In the previous question relating to undue influence, this specific question was not there. They had just asked a general question, what is undue influence, define it, and what are the essentials. So if it is for about 4 to 5 marks, you need not write all of these in detail. But since here they have asked you detail me, you will exactly cater to what is asked. This was also January 2025 for 6 marks. I was just thinking, how are 2 questions relating to Unit 3 itself asked for 6 marks? Maybe it was an option. So yes, in January 2025 paper, there was a question which gave you options, either this or this. So within the options also, you had an option. Yes, that's why. And this was also asked in January 2026, the previous attempt before this video. I had just seen the question paper, so I thought I'd include that as well. January 2026 also, 6 marks clear this question was asked. That time it wasn't an option, it was just asked. But in 2025 attempt, this was an option. Anyway, doesn't matter to us. Question number 13 is something we just covered. Explain the cases. Oh no, that is over. Question number 13. Whether the threat to commit suicide is coercion. We just learned that. Yes, it is. Reason? Because it is forbidden by IPC. Question number 14. Case study questions. Yay. Mr. A, an employer, induced his employee, Mr. B, to sell his 1-room flat to him at less than the market value to secure a promotion. Okay. Mr. A, you are telling Mr. B, if you want a promotion, I will give you the promotion. But what do I want from you? I want you to sell the 1-room flat at less than the market value in exchange. Mr. B sold the flat to Mr. A for the promotion. Not bad, Mr. B. But later on, he changed his mind, thank you, and decided to sue Mr. A. Fine. Examine the validity of the contract as per the provisions of the Indian Contract Act. Employer inducing or blackmailing or mentally torturing or putting mental pressure on his employee. Now that I have given you the answer on the plate. Come on, tell me. Yes, undue influence, section 16. What is the consequence of this section? The section says that if an agreement has been entered into using undue influence, the aggrieved party can make this contract voidable. Contract is voidable at the option of the aggrieved party. So the question here is asking us that, can Mr. B file a case on Mr. A? Of course he can. Mr. B is the aggrieved party here. Mr. B can proceed against Mr. A since the contract was induced on account of undue influence. Okay. Let's look at the next question. Question number 15. Mere silence does not amount to fraud. True. Oh, I've forgotten the open inverted comma here, okay? Yes. Explain the statement as per the provisions contained in the Indian Contract Act. Direct question, we saw it in the beginning of this video. Mere silence does not amount to fraud. Silence is equal to fraud in those 2 cases. So you will have to elaborate all of those points. I told you mere silence is a very important topic. I kept screaming this in class. Screaming Allah, telling you in class. Those who know me really would know it is screaming, but for the rest of you, I don't scream, okay? December 2023, 5 marks. Next example name, question number 16. Explain the term wagering agreement in the light of the Indian Contract Act 1872. So when we say wagering agreements, we are talking about section 30. Agreements involving the payment of a sum of money upon the determination of an uncertain event. Kahin to suna hoga nahi, you have studied this. Also explain some transactions resembling with that of wagering transactions but which are not void. Let me take you to that area. Last topic of Unit 3 this was. Oops. Yes. Wagering agreements, section 30. So you will write the meaning of wagering agreements, explain that it is void, unlawful as well as illegal. It is a game of chance. One party should stand a chance to win while the other should lose. Only then it would amount to a wager. No parties should have any sort of control over the event. The event should be completely uncertain and the party should not be interested in the event otherwise than the amount which they have put at stake, right? Otherwise than their stake, they really don't care about any of the other events that are happening. So once you've explained this, the question also asked us, there are some cases which are resembling a wager but aren't wager. So here we have learned some other points. Now, whose other points may we have a few topics. The first one, crossword puzzles and competitions. Now there are two kinds of crossword puzzles and competitions. Case number one is where you are winning if your solution is corresponding or matching with the solution that is prepared by the person who has set the crossword. So how are you winning here? You are winning because of your luck, because your solution is matching with their solution. Now that would come under a game of chance. But there are other crosswords or other competitions which involve skill, which involve testing you based on your intellect. In those cases, there is no question of wager allowed. So while it may come under this topic of wager, those cases which are purely based on your skill or intellect would not amount to wager. So that is your first point. Then, speculative transactions, share market transactions which are authorized by the Securities Exchange Board of India, absolutely valid. Chit fund transactions are also considered valid. And last one, contracts of insurance, which you have learned in detail under Unit 7, which is contracts of indemnity. Those cases are also valid. So all of these 4 points will form a part of your second part of the question, this one. Some transactions which are resembling with that of wagering transactions but which are not void. 6 marks के लिए June 2024. Okay. 17th question. Consent is said to be free when it is not caused by fraud. Yes, sir. According to the provisions of the Indian Contract Act 1872, answer each of the following. What do you mean by fraud? Section 17, same thing, write the whole thing. Then, what would be the effect of fraud upon the validity of a contract? What is the effect of fraud? It is voidable. Okay? And state the instances in which a contract is not voidable. But if this was the length of the question, why would they just ask what is the effect of fraud? The answer cannot be just voidable. There are 2 other points there. We will pick up those 2 other points. We are looking now at section 17, the final part of fraud, which was not asked in any of the previous cases, has been asked now. What is the effect of fraud? So we know that any agreement or contract which has been entered into using fraud is voidable at the option of the aggrieved party. Itna hame pata hai. What are the remedies available to the aggrieved party? Case 1, aggrieved party can resign the contract within a reasonable time. Obviously, you have the option to make it voidable, so you can resign it within a reasonable time. Case 2, you can also sue for damages. Yes, the party has imposed fraud on you. The least you can do is sue for damages. But there is one more effect, which was so far not present in any of the topics that we discussed, is to restart with the representation, which is true. Matlab, you did want to continue into the contract, but you are requesting the party who had used fraud not to continue that fraud element anymore in terms of your contract. So whatever communication is exchanged between both the parties, it should be with only true representation and no false representation. So the contract has to be restarted, or the whatever essential questions or queries were there as part of the contract, they have to be addressed. The terms have to be imposed which do not involve the element of fraud anywhere, and the representation that is made by that party should be true. This is one more effect that we have learned. But what are the exceptions where a party cannot make a contract voidable even though fraud was present? case 1. I like these exceptions. Like one of my favorite topics to explain in class. Contract is not voidable if the aggrieved party had means of discovering the truth with ordinary diligence. Matlab, if you are given the chance to the aggrieved party, you have lied, yes, you have lied. You're given them a bottle, okay, and you're telling them that this bottle is filled with oil. Anybody who takes that bottle will know that the bottle is empty. Now you're giving the aggrieved party that bottle. You're telling them that, hey, take this bottle, check it properly. So you had, as an aggrieved party, you had the means of discovering the truth. You did not opt for those means. You did not check the truth properly. Now you cannot blame the seller for using fraud. There is a caveat which tells, let the buyer be aware. So that logic will apply here. If the aggrieved party had means of discovering the truth with the ordinary diligence here, just to take that bottle from the hand of the seller and check it does not involve rocket science. Through ordinary diligence or duties itself, you will find out that there is no oil in that bottle. So you could have discovered the lie, but you did not do that. That's on you. You cannot avoid the contract after that. One more. The fraud wasn't the reason for the consent. Here, we have taken up a case where a person's name was mentioned in the prospectus as the director, but the party who purchased shares did not really care about the fact which was mentioned in the prospectus of that person being a director. He simply purchased the shares because he wanted to purchase the shares of the company. Yes, that fact about a person being a director was a lie, but that was not the reason the consent of the party was received. So the fraud wasn't really the reason for the consent. So obviously, if you're able to prove that in the court, that cannot be the grounds for avoiding the contract. So these are the two exceptions where the contract is not voidable. See, again, I could have just shown you that. I got carried away and started explaining this topic. Anyway, when it comes to fraud, somehow it becomes a little personal. Last one, 18. Some objects in consideration are unlawful. Yes, we know that. We've been learning that since section 23. Define any 6 with reference to the provisions of the Indian Contract Act 1872. Yes, ma'am, you have 6 cases where the objects in consideration are unlawful. Forbidden by law, defeat of the provision of law. The same points have to be covered. Fraudulent, all of those things will be involved here. You know the 6 points, we just ended with agreements opposed to public policy. So those 6 points have to be explained for this, and that will give you 6 marks asked in the immediate previous attempt that we just had. So with this, I think we finish all the questions relating to Unit 3. Please, again, understand that these are just revision-based videos. You can't watch these videos if you have no idea about the chapter. So I always stress this in classes. Step 1 is understanding, which is completely my responsibility. It is my responsibility to make you understand whatever is being there in the material or in the subject of business law. Step 2 is entirely your responsibility, which is you studying. Unless and until you study whatever I have taught you after you have understood it, we cannot do the step 3 combined. This is step 3 where it's a combination of you and I learning together. So please watch these videos only once you have finished. And if it's too overwhelming for you to finish the whole act and watch, don't do that. Wherever some other units are involved, I've always mentioned that this is relating to another unit. So go unit wise, but make yourselves thorough, because not just understanding or not just memorizing everything that is given in the act is important. It's a combination of both of this that will help you actually crack it. So I'll see you in your next video. After this video, take a good break, do your thing, study Unit 4 and then watch the video relating to Unit 4. Have a good day.